Hi, good evening. This is Rahul Reddy. Along with me is my business partner, REDDY NEUMANN. REDDY NEUMANN bring you news every Tuesday at 5 p.m. Central Time. For those people who are listening to this on YouTube or Facebook Live, you can post your questions at Facebook and YouTube. We will try to answer as much as possible. Emily, what do we have today?
So the big news from this week is the public charge rule, which is a new regulation that the Trump administration has put forth as a way to enforce our existing laws that require every immigrant to prove that they won't become a public charge. They're not going to go on welfare, and they are able to be self-sufficient. So we have new regulations that are about to come out and will take effect in October, I believe. We'll talk about how that's going to impact high-skilled immigrants specifically. We also are seeing site visits happening for STEM OPT employment. We knew that this is something ICE could do back when they created the 24-month STEM extension, but we really didn't see any site visits until very recently, so that's happening now. We're also seeing more situations in which USCIS is going and looking back at prior H-1B approvals, and if anything was improved in error even 10 years ago, they're going back and revoking those, and what is the impact of all of the subsequent H-1Bs after that. And then we'll talk a little bit about what's going on with H-1Bs that were filed in the lottery this past April, where we're at on the return of those that weren't selected and what other options you might have.
Emily, this has been a big rumor right now. It's going to affect immigration, but doesn't look like the public charge thing will have much effect on the business-based immigrants. Do you feel that?
Yeah, I don't, the whole idea behind this rule is that immigrants that are coming here should be able to prove they're self-sufficient. Well, you're coming here for a job, so the job offer itself should be proof of that. Where we are going to feel the impact is, I believe they're adding a new question on the I-129 form. We've seen the draft of that before when they were announcing this rule, where they're going to ask, has the H-1B beneficiary, for example, used public benefits within the past 3 years? And so that if you have, and you weren't supposed to, and you're not exempt from this requirement, they could potentially deny your extension or a change of status for that. That's the new part of the rule, because before this issue really only came up at the time you're applying for the visa at the consulate, at the port of entry, and when you're applying for your adjustment of status. It's never been applied to non-immigrants filing a change of status or an extension of stay. But I think most employment-based applicants probably are not using public benefits. They're here for jobs, high-skilled immigrants.
So Emily, when I've looked into the law, it says mostly those people who are looking the food coupons and other benefits, which normally, most of the business immigrants that you and I normally see, at the most, they're taking the benefit of public school where the kids go, and of course that is not included in it, luckily. So it's not going to substantially affect them. However, though, as you pointed out, that when they're adding all these things at different places, though, we are already delayed everything. H-1B is delayed, H-4 is delayed. All business immigration benefits have been delayed right now. So this is going to cause extra delay for them to check, verify, do all those things. So do you think so that it's going to delay, or do you think so substantially it might affect any of these people?
Yeah, I definitely could see this causing even further delay from what we're seeing right now. And they have the option of asking you to fill out an extra form. I think it's the I-944 or something like that, where then they can do ask you all of these questions about your financial history. So of course, if you get a request for that, it's going to delay further. But even just to have them go through this additional question and review that, I'm sure they'll use it as an excuse to delay, whether it actually
Some questions that came up on this, Emily, is that what if I'm on H-1B visa and I went to the hospital, they give me a bill of $20,000, I only paid them $5,000, rest of the $15,000 they waived it. Will that affect my green card application?
Yeah, so I think for emergency medical, that falls under one of the exemptions of the rule.
But still, it should be a private hospital, not the government. I didn't took any government benefit.
Right,
okay.
Right, yeah.
Yeah, so that should not affect guys. And also, sending to public school, no, that will not affect you to getting But if you are getting any food coupon saying that you're a lower income person, you may want to check with your lawyer before you take any of those benefits. But mostly, I think so, 99% of the business immigration client should not be, but the 1% of the people, I would strongly recommend them to consult a lawyer. On the issue of the FDNS visits, Emily, used to happen for the H-1Bs. That is, fraud detection unit used to visit for H-1B, check to verify if they're actually working for the employer for the position for which they are being employed for. Now you're telling that the same kind of thing is happening for the STEM OPT people. If it's happening for the STEM OPT people, who is visiting and what's going on that? And what are they actually checking on?
Yeah, this is a different agency. So ICE, Immigration Customs Enforcement, is in charge of F1 students in the whole SEVIS system. And so when the regulations that created the 24-month STEM extension and the training plan requirement came out, they did include a provision that said ICE could conduct site visits to verify compliance with the requirements. So we had not heard of any site visits in the 3 years since this rule came out, but starting last month, we started hearing from clients from companies that were receiving these emails letting them know that in 3 days or in a few days, an officer would come to verify. So these seem to be less frequent, and also not going into as much detail as the H-1B FDNS site visits. They're very general, just kind of making sure the business actually exists, making sure that the person is doing what they said they were going to do on the training plan. From what we've seen, they've not asked for any documents yet. Of course, the way site visits happen always is changing over time. That's how FDNS site visits used to be, just very simple. Now they're just emailing these long questionnaires and asking for additional documents.
So if I'm an employee who is working on the STEM OPT, Emily, what should I be aware of when I'm going to get this visit? What should I be prepared of? What should I be expecting? And what are the consequences if anything goes wrong there?
Yeah, make sure to just refresh your memory on the 983 form that you and your employer have filled out regarding what your job title is, what your salary is, what your job duties are, the way that the training plan is going to be carried out, what you're supposed to be trained on, and make sure you're actually doing those things with your employer while you're working at that location. Other than that, I can't think of a whole lot of, because
what I'm thinking is that if I'm the STEM OPT person working at, I should have the 983 form with me available. And I should look into the 983 form to see who the employer is, who is the person who's supervising, what are the job duties, how is the employer controlling the employee, and look into the 983 form and any the evaluations that are coming up. I will look into it, I would read it very carefully, and if there is any disagreement on the 983 form, I feel it, then I will contact my employer or employer's lawyer to verify the information. So if the STEM OPT students are well prepared with that 983 form, now all these STEM OPT students, STEM extension OPT students know that what a 983 form is. It is the same form that they have used to get the STEM extension extended. The employer has signed the document. The employee has submitted that to the DSO, got it endorsed, and they have filed based on that endorsement of the I-20, they have filed a 765 extension for the STEM. So they should be well aware of the 983 form, read it very carefully. And if there is any discrepancies, they feel there is discrepancies, they should contact their employer or employer's lawyer or contact a private lawyer to check if that is if there is any discrepancies that might affect them though. So if they are well prepared with 983, I think so they should be good. Do you think so? If there is any disagreements on the 983, then you might be in trouble.
All right. So we're starting to see more and more often in situations where individuals are filing their H-1B extension or even filing a transfer. They've been on H-1B for several years, and then all of a sudden USCIS is bringing up an issue from years ago and claiming that they're going to deny the extension. For example, situations where they're claiming now the person is subject to the cap, maybe because they filed in the master's cap with a degree that didn't qualify them.
So it's the unaccredited universities that they've applied for the H-1Bs and got their H-1Bs approved in the cap, but in the masters. For example, Stratford University, for example, in an unaccredited university, they got a H-1B long time ago in the cap. Are you telling they're coming and revoking some of those things?
Yeah, these are, 2008. They're going back.
Did you say 8 or 18?
8, yeah.
Okay.
They're looking back 10 years at that original petition and now finding that it never should have been approved in the master's cap, and therefore saying you're not counted properly, and so now you are subject to the cap and we have to deny this application. We're seeing that issue, as well as issues with people that had cap exempt employers at one point and switching to for-profit.
You mean to say the affiliated university,
right?
Things who applied H-1B as a cap exempt.
Yeah, nonprofit or affiliated with a university or research organization. At one point, they had filed that cap exempt, and now the government's coming back saying, well, maybe it didn't really qualify as cap exempt, or they switched from cap exempt to cap subject without going through the lottery somehow. They're finding all these errors, supposedly, that the Immigration Service made years ago and using those as a way to deny current applications.
We also noticed that if the H-1B has been filed for in-house cases, which we have in our previous presentations many times have pointed out very clearly that if there is a questionable in-house thing, you should contact the immigration lawyer. And the USCIS is now going back and looking the first H-1B application filed and questioning that the first H-1B has not been approved. So practically in the three situations, as Emily has pointed out, one is where the person has been counted into cap under the master's quota when they're not supposed to, because they have degrees from unaccredited universities or universities that are for profit. And the second situation, was Emily pointed out, was cap exempt organizations, but they are actually not cap exempt organizations now. And the cases where the people have filed H-1B in the in-house, which never existed. These are the three kinds of scenarios where we have seen USCIS questioning and telling that their own approval is wrong. And they are trying to revoke those H-1Bs. Now, Emily, why, if they are looking into 2008 H-1B or 2010 H-1B, why would it impact the student right now? Tell me, explain that.
Yeah, that's the big thing that I think people are unaware of. I mean, if this is your first H-1B that they're going back to, and now they're saying it never should have been approved, they're basically saying you were never counted in the cap, therefore you are still subject to the cap now and have to go through the lottery in order to get into H-1B status. So basically your status the whole time is going to be called into question, and you have to go through the lottery again.
Emily, on the lottery system that you said in the 2019, you guys have filed H-1Bs. Of course, not all the cases that you filed got selected in the lottery. You're not God, of course. And what happened to those things that got rejected in the lottery? Did they come back, or what's the situation?
Yeah, we're still getting those back every day. So as of yesterday, we had gotten back about 75% of the cases that we are sure did not get selected. So we still have about 25% more to go. We're getting a couple in every day. So probably, I would say within the next 2 weeks, we should be receiving those last petitions that didn't get selected. And our office, we usually inform the employer the same day or the next day that we received it, and instruct them to tell the employee that it came back, so that they can make whatever plans they need to make for their current status, to make sure that they are going to continue that status. One of the common questions that comes up for those that didn't get selected are what other options might be available. I think that this is always a difficult conversation to have every year, because the options are very limited. Unless you have the option of a TN visa, if you're a Mexican or Canadian citizen, or Australian citizens have the E3 visa, which is very similar to an H-1B. Or if your company has overseas offices where they can send you there for a year to potentially qualify for an L1 later, those are really your main options. We always get the question, should I go back to school and do day one CPT? No, please don't do day one CPT, even if you're doing a PhD. No, the schools that are offering these PhDs with day one CPT, I have really questioned whether those are good schools to be going to.
So what's your problem, Emily? It's a non-profit higher education institution authorized by the government that is giving the work permit for a doctorate degree. Why are you saying no?
Well, are you going to school or are you working? The whole purpose of studying a doctorate degree is not to allow you to keep working at your end client 40 hours a week when you're studying a PhD. I mean, before I went to law school, I was in a PhD program. There is no way I could have worked even 20 hours a week and properly studied in my PhD program, let alone working 40 hours a week. You know, these schools are not requiring people to attend classes, and people are not able to get the F1 visa. The consulates are denying them. People are getting denied at the port of entry when they travel. That should tell you something right there, that there's something not right.
But there are 100,000 plus students who are on the day one CPT. You're telling they may all be wrong?
Absolutely. Yep. We've been trying to warn people for a long time. We see the issues that come up later with the H-1B, particularly when you file that change of status. A lot of people get the change of status denied. And right now, we don't have the unlawful presence memo in place because there's an injunction keeping it from being enforced. But if that were in place, I think we'd have lots and lots of people who would be banned from coming back into the U.S. because of these day one CPT programs.
REDDY NEUMANN piece, he does get a lot of these questions when we do post in the Facebook and YouTube, guys. People challenge us, why not? I mean, believe us, it's easier for us to tell her to go day one CPT. We don't have options there. And sometimes people are cornered into situations where they pick up day one CPT. But our advice is that you are harming your long-term future by taking the day one CPT. Don't choose that option. I'll tell you one other example. It's not that REDDY and NEUMANN PC is odd in advising you not to take the day one CPT. One simple example for you guys is that there are about 9,000 educational institutions that are authorized to give CPTs. Out of those 9,000 education institutions, there are only 7 or 8 educational institutions that are giving day one CPT. The characteristics of these day one CPT universities, or 7 or 8 universities that I'm speaking about, is that they don't require students to attend classes for more than 6 days a week. When I was going to law school, I was going to 6 days a week. And now these universities are telling that you can only attend 6 days a year. I mean, that's a good sign for you that that's not a good university. Second sign is that they are not requiring any prerequisites. No GMAT, no GRE, nothing required. Just come in. They're not even, and the semester starts whenever you want to have your semester started, and that looks very odd. We strongly recommend, guys, that you do not join and hamper your future to stay in the United States. So please don't take that option if your H-1B is not selected.
Time to go to some questions. Anu from Facebook wants to know if getting free education from public school for H-1B dependents is considered under this public charge provision. What would you say on that?
I would say no, it will not. You're taking the school education, that's definitely not considered to be, even if they're giving scholarship or anything on that, if you're fine, I don't see any problem with that thing. Question comes from YouTube. Shankar is asking the question. I'm working for a direct company. Now I'm moving to a different state where my office doesn't have a location. I'll be working from my home. Will it go through without an issue? Well, Shankar, the chances for getting an RF denial for a direct employer to work at your home is very low. I mean, the chances for problem is very low. But to tell you the truth, Shankar, that nothing is going to happen, no problem is going to occur. We can't tell that, but your chances are very high. Now, since you're filing an amendment or amendment plus extension, if by any chance you get the denial, you can always go back to the original location and continue working there. So let's say, for example, your company is in New York, you're moving to Florida, and you get the amendment denied, you can next day fly to New York and start working in New York. So you can do that, but no guarantees that it's going to go through.
Ramakrishna from Facebook has a question about L1 to H1 to filing an H1 transfer. So in this situation, came originally on L1, changed status to H1, filed an H1 extension, has never gotten the H1B visa stamped and wants to know if they can transfer to another employer. And the answer is yes. You don't need to have the H1B stamped. The only time you need the stamp is if you're traveling. So if you were to go out of the US in order to come back in, you do need an H1B stamp. But once you're here, every time you file something, you're getting a new I-94, and that I-94 is what allows you to stay in the country, not the visa stamp.
Question from Arvind. That from YouTube, his company is not giving the I-140, copy of the I-140. Can he directly get from USCIS? You can file a Freedom of Information. It's called FOIA. You can file that. You can go to USCIS website and just type in Google FOIA, Freedom of Information Act, USCIS. It will take you a form. You can file an online application. It takes about 60 days for you to get a copy of the I-140 petition. It's not an actual I-140 approval, but it will substitute all what you needed for an I-140 approval. That can be considered as an I-140 approval. You can keep it. It takes 60 days. We normally don't recommend to go through a lawyer. It's so easy, online, no filing fees, nothing. You'll get it in 60 days.
Deepthi from Facebook had applied for an H1 and H4 and EAD renewal. H1B got approved, but then had to travel. So obtained the H4 visa stamp in order to come back into the US, and now wants to know what happens to the pending H4 that was filed along with the H1B. So the pending H4 is going to continue to be processed. A pending extension is not abandoned by the travel. The difficulty is that your I-94 number has changed. So you probably are going to need to try to submit your new I-94 to your pending I-539, so that when that approval notice comes, it will have the correct I-94 number on it. You do need that H4 to continue to be processed, because if that gets withdrawn, because you don't technically need the H4 anymore, your EAD is going to be denied. So you have to have that H4 continue to process so that you can get the EAD. Know that you might end up with a wrong I-94 number on your approval notice, and you might need to travel one more time to get the corrected I-94 number.
Richie has this question: how long can somebody have a bench between the projects while on H1B? From YouTube, we don't have a direct answer to that question. As long as you're getting paid, you should be fine, but any longer period, I wouldn't define a particular period, any longer period is not in your favor. It is going to go against if you're on a bench for a long period of time. Also consider that if by any chance you are eligible for H4, you may want to throw a H4 application to be on a safer side.
All right, on Facebook, I had a question about I-94 expiring and filing a change of status or extension. I'm sorry, I lost the question. And the receipt notice hasn't come in yet, and the individual wanted to know if they were still if they could still stay in the country. So as long as the I-539 was properly filed before your I-94 expired, yes, you can stay in the country. Once you get the receipt notice, it should have that receipt date on it to show that it was timely filed and can continue to stay. So yes, you can continue to stay even while you're waiting for that receipt notice. If the difficulty is if for some reason the application didn't dang your I-94. So that is one risk of kind of filing real close to the deadline there, but as long as it was properly filed and received by the Immigration Service before your I-94 expired, you can stay while you wait for that receipt.
Ashish has this question from YouTube that he was on H-1B, but he now moved to H-4. Can he work on the H-1B receipt notice? He is not subject to cap. The answer to the question is no. You have to wait for the H-1B approval before you can start working on this on the H-1B. Jose has a question from YouTube. Does ICE visit the day one CPT students too? This STEM extension part is not is different than that of the day one CPTs. The last time day one CPT visited ICE visited the day one CPT was that they visited 600 students and detained as many of these can on one single day. That happened in February of 2019. You can look into the news. That's one of the reasons why we keep on telling, and even before February of 2019, we have been telling that day one CPT is not good. The time when the ICE visited was that the day one CPT student was that it was the University of Farmington. None of these students were going to school. They are not attending the school. That's one of the reasons why all 600 people, they went and visited, but they arrested about 300 to 400 people on one single day. So yes, day one CPT students need to be careful. They may be visited. It's not that they cannot be visited. ICE can visit them.
Somebody from Facebook has an H-1B with an RFE that was already responded to, and then to maintain status joined a CPT. Just let me say first that CPT is not a status. You're continuing your F1 status and getting CPT, which is not a good option. But the question is, what's the possibility of getting another RFE? It's definitely a possibility. We did see that last year on a number of cases. After we responded to one RFE, we got a second RFE specifically on maintenance of status during F1. They pointed out the new I-20 showing in the record. So yes, USCIS does look into that, and there is a chance of a second RFE.
Richie Boy has this question. I'm a US citizen. What is the best option to get a nephew and niece? They both are 11. Is adoption an option? Mr. Richie from YouTube, the adoption must be true adoption. It cannot be any fake. That's number one if you are adopting. The second thing is that you must have a custody of the kids, sole exclusively custody for you and your wife, and nothing to do with their natural parents for a period of 2 years. In other words, if your sister and you are staying in one home and your sister kids are at your home, then that will not be considered as custody. If your sister is staying in India and their kids are staying with you, then that will be considered as a custody. The adoption need to happen before they are 16 years old. But if the sole purpose is just to give them the green card, not to take them as your own son and child, immigration is not the thing for you. No, you cannot do that thing.
Rakesh from Facebook has a question about completing the DS-160 after an H-1B petition has been denied. So in this situation, you know, the DS-160 asks the question, have you ever been denied a visa or denied admission or failed to maintain your status in the United States? A denial of a petition, the I-129 petition, is filed by the employer. It's not you personally being denied. It is the company's petition that has been denied. And an I-129 petition denial that doesn't say anything about a failure to maintain status is not the type of denial the DS-160 is referring to. The DS-160 is referring to denials of the visa stamp at the consulate, denial of admission at the port of entry when you're trying to come into the U.S., or a failure to maintain status or work without authorization. So I don't believe a denial of an I-129 petition that has nothing to do with a person's status has to be disclosed on the DS-160.
Abhinav has this interesting question. If I'm an immigrant, I would have this question too. For the quota of the green card, do they look into the country of birth or do they look into the citizenship? The answer, Abhinav, is that it is the country of birth, not the country of citizenship. So for example, if you're born in India and you move to Canada, you got a Canadian citizenship. For the purpose of the green card, you will be considered as Indian. For the purpose of the non-immigrant For example, TN visa, you will be considered as a Canadian. For the purpose of the green card, though, you will be considered as Indian. Now, on the contrary, let's say, for example, if you were born in United Arab Emirates, let's say Dubai, and you are actually never hold a citizenship of Dubai or UAE, you were always an Indian citizen. For the purpose of the green card, you may be considered as a Dubai citizen.
Sorry, I'm having some
Satya has this question:
difficulties.
can we apply H-1B for from work from home and client is a different state? Yes, you can apply for a H-1B when the client is in a different state. Absolutely, that's not a problem. You can, but you need to have a clear documentation when you're filing the H-1B. We normally recommend to put the location both on the LCA location of both H-1B and where the employer is located, and also on the where the employer is located, and also your home location.
One of the questions that popped up on Facebook was regarding the H-4 EAD litigation. I don't remember who it was, but someone was asking kind of what's going on with it, what is our success rate with that. And so it's, for the H-4 EAD litigation, we've filed multiple lawsuits. These are done over time. And so some of the lawsuits that were more recently filed, we haven't seen results yet because it's too early to expect results. The government has 60 days to take action after we file this lawsuit. So we can say that in the first one that we filed, 100% everyone who was included as a plaintiff did receive their H-4 and their EAD approvals already within 60 days of the filing of that litigation. The second litigation has not yet reached 60 days, but people have been receiving their approvals as well. Beyond that third litigation, I think we've started to see approvals in that, but it is all dependent on just when we filed, and the government has 60 days. So there is a time lapse between when we file versus when we start seeing results on those. But it seems to be the only thing that's working.
One question is that once the adjustment of status has been filed, the priority date is current. How long is it taking for them to adjudicate the adjustment of status? It's taking approximately around 16 to 18 months. And nowadays, they do have a interview. Without the interview, they are not giving the green card. So previous to March of 2017, there was no interview process. And right now, there is an interview process. And because of the interview process, it's taking a longer time for them.
One of the questions was about the STEM OPT site visit, especially if it's a situation where you're at the third-party placement. The officer so far has typically gone to the employer's location, not the end client location. I think it is going to depend partly on how the I-983 form was filled out, but they could go to either location.
Abhinav, the same Abhinav to YouTube has a good question, that what is the processing time for the H-4 plus EAD in Texas Service Center? The problem is Texas Service Center recently had the jurisdiction of the H-4 plus EAD, so it's very premature at this point of time to guess the timings though. We may be able to tell it probably 2 months, 3 months, right? But we are unable to guess it at this point of time because they recently got the jurisdiction July of 2019. Question from Dharma comes, Emily, for you is they filed an employment-based green card. Can they file an I-130 while the employment-based green card is pending?
Yeah, absolutely. There's no issue between having both of those pending at the same time as long as you qualify for both. I don't see any problems with that.
I want your attention on this one, Emily. What is the difference between the H-1B revocation and H-1B withdrawal? What's the difference between both things?
Yeah, great question. An H-1B withdrawal is done by the employer. That can either be after an H-1B is approved and the individual is no longer working, the employer will ask USCIS to withdraw the approval, or it could be while the petition is still pending. the employer again would request withdrawal of the petition. A revocation happens after the H-1B has already approved and is typically in a situation where USCIS finds new information or is revisiting that approval because there was gross error in the decision, and now they want to reopen the application. So after an approval, the government could come back with a notice of intent to revoke, reopening the application and giving the company a chance to respond to the reason that they intend to revoke. So that is the difference between those two.
Emily, when somebody files a H-1B application under the change of status, if they want to convert into consular processing, especially the day one CPTs, we are receiving a lot of, almost everybody gets a maintenance of status issue. Is there a particular process? Do they need to use any form to convert into change of status, into consular processing?
Yeah, so the fastest way we've found to accomplish that is usually in response to the request for evidence, just including the request there. Because if you don't have a request for evidence, if you're just sending the request to USCIS, it may be difficult to get whatever you're submitting to them past the mailroom and to the officer that's actually working on your file in time before they're going to adjudicate the application. So in response to the RFE is one of the ways to do it, or you could include it potentially in an upgrade to premium processing. Those would be the easiest way. There's not a form for it. It's usually more just a request in a letter.
Aditya has a personal question. Maybe you need to be in there too. Aditya Chandal from YouTube is asking, I got an admission from an Ivy League university. In the current political scenario, is it advisable to join? He's an H-1B and he's from a backlogged country. That's a tough choice. Ivy League college, depends on your finances, I think.
Yeah, that's a good part
And
of
then
it.
it depends on what you got the degree in. Yeah, if it's a Yale Law School, I would leave it. Harvard Business, I would leave it. But if it's a psychology in a top school, I don't know. It's it's a personal choice. Everybody is different here, though. It's just the whole backlog situation of per country limit is throwing everybody out, Emily. I have a lot of questions, and you do too on the Facebook. What's the update on the 380 Senate 386?
Yeah, I don't think we have any update. It's really just stuck. We need some action from the Senate Majority Leader in order to either start some debate on it or get it moving in a committee. I have not seen anything being done on it. I don't know about you, and it seems to be stuck at this moment.
Is using COBRA, the insurance COBRA, a public charge, Emily?
I don't believe so, no.
No, I don't think so.
No, you're
COBRA.
paying for it.
You're paying for it.
That's for sure. VJ from Facebook had the H-1B selected this year, found out about it in April, but has received no updates on the status until now. What should he be doing? So you're in the same boat with probably 30% of the applicants that filed. That's very normal that people have not received any update as of right now. A lot of the petitions that we filed last year that did not do premium processing were still pending in August, still pending in September, still pending in October. We had a number of petitions that were still pending in January of this year from last year. So nothing to do at this point. It's still within the normal processing time. You may want to consider upgrading to premium processing, especially if you're on the cap gap, because your employment authorization ends on September 30th. And if your H-1B is not yet approved, you have to stop working. So if you're in that cap gap situation, I highly recommend you consider upgrading to premium processing so that you can get your approval by October 1st.
Rashmi has this question. Her son is 16-year-old. Priority date is 2011. When should she file the F1 and keep him in status? I would recommend filing the F1 when he turns 19, 2 years before 21, because they're taking a long time to adjudicate the F1 visa. Now, here's the question that Rashmi that pops up immediately is that what you're concerned is that if he moves to F1, can he file the adjustment of status if your priority date becomes current? And Rashmi, yes, he can file the adjustment of status even though he's an F1 visa. He can file the adjustment of status along with you, absolutely not a problem, as long as he did not turn 21. So if he moves to 19, he moves to F1, and the priority date becomes current, you can file the adjustment of status. VM Reddy from YouTube has his question. His license has been suspended because of some miscommunication between the DMV and the traffic violation. Court order to remove that suspension. Will have any problem in the stamping? The answer is no, you should not have. But make sure that you keep all the documentation with you. If by any chance any arrest warrant has been issued just because you didn't pay some dues and it was a mistake, make sure you have all the documentation at all times with you.
Question from Facebook, have we been seeing H-4 and EAD approvals from the Nebraska Service Center? Off the top of my head, I feel like we get them
through the litigation, or through he's speaking about.
It doesn't say.
Through the litigation, definitely we have seen good number of things coming from Nebraska Service Center, because the number of people that we filed through litigation is more higher. So but in general, though, what we noticed other than the litigation, Nebraska Service Center is backlogged much more than Nebraska Service Center is backlogged. I think so. Vermont Service Center is also backlogged more too. In that way, California Service Center is a little bit better on the H4, but Nebraska and Vermont Service Center are very backlogged. And we can't comment anything on the Texas Service Center at this point of time.
Question from Facebook, can an old employer file the I-140 for me after I've left the company through an H-1 transfer? So technically, yes, they can. Should they is the better question, because the company, when they're filing the I-140 petition, they are confirming to the government that they're keeping that job open for you, which could be questionable if you're no longer working there. And the other issue that comes up is with can the company support the petition? Does their finances allow them to prove that they have the ability to pay, which is a required part of the I-140, and that for smaller companies can be difficult if you're not working for the company anymore.
Farah Hamad has this question from YouTube. Emily, I need your attention on this one. She filed H4 to F1 for the daughter, but the daughter turned 21 on June 25th. F1 is pending.
Mm-hmm. I hope that she filed a B1, B2 bridge in between. Otherwise, that F1's going to get denied. Get denied.
And can you explain the rule, Emily, why she filed the H4 before she turned 21? Why would her H4 be denied if she didn't file the bridge B1 application?
It's very complicated, and it has to do with the program start date in the SEVIS system for the F1 students. So when the F1 has been pending for a long time and still not approved, it's likely that the program start date got passed while the F1 was pending. The school is automatically going to move the program start date to the next semester. They keep rolling that start date the whole time the I-539 is pending. But in order to be eligible for a change of status to F1, you have to be able to show that you're maintaining your current status up to within 30 days of the program start date. So that was very likely the case when you initially filed, but then when the program start date got moved to January for the spring semester, for example, now she's already turned 21 and the H-4 status ended in June. You have nothing to bridge your status from H-4 to the F-1 start date, which has been pushed forward until January. So that's why we have to file this B2 bridge application in between. So unfortunately, I think you'll have to look into going for F1 stamping to get her back into status.
Yeah, and there are other issues since your I-140 is approved. So I would recommend that if you have not filed a Bridge B1 application, you should contact a lawyer ASAP. Saptarishi has this question from YouTube. Can a H1 be transferred after the H-1B is withdrawn. So he's working with company A. Now, a company has withdrawn the H-1B application. Can he move to company B? There are some rare exceptions available. Assuming that you have left the job within 60 days, assume your I-94 validity is still there. And if they have withdrawn it, you have a grace period of 60 days. If in that grace period with the I-94 validity, you can apply for the transfer. But if you have crossed the validity period, the 60-day grace period, or if you have crossed the I-94 period, you should leave the country immediately, Saptarishi.
Sorry, I'm still having some technical difficulties.
Mukesh has this question. I have an approved I-140 with my previous company. Can I renew the H-1B extension beyond the 6 years based on the I-140 approval? The answer to the question is yes, you can apply for the H-1B beyond the 6 years, absolutely not a problem. Assuming under two conditions, I-140 must have been approved for more than 6 months.
Hari has a question. What happens if my H-1 extension gets approved while I'm traveling internationally and my I-94 is now valid until January? So it depends on whether your visa stamp has expired or not. If your visa stamp has already expired, you will use your new approval notice to apply for the new visa stamp and come into the U.S., and you'll be given another I-94 when you enter. If you have a valid visa stamp, then you can use that visa, even if it's with a different employer, as long as it's an H-1B visa stamp, and show your new approval notice at the port of entry and be granted entry to the validity period of your new approval notice. But make sure you check your I-94, check the date that they stamp in your passport to make sure it matches your I-797 end date, not your visa stamp end date. They're supposed to give it to you for the full period of the extension that you've been approved for. Sometimes they make a mistake on that, so you want to correct it before you walk away.
Kalinga has this question. He has an RFA for an I-130. Can he supply the Skype, email communications for bona fide relationship? Yes, you can supply anything and everything that you have. Nothing is prohibited in it. You can do I-130s for I-130 Skype, email, WhatsApp, anything you have. I will go everything that you can. Skype is good. You can provide the history of the Skype. If you have WhatsApp, I will go print every WhatsApp out. Any communication that you can print out, any communication that you can show is good. Absolutely not a problem. One thing is, to the question that came from Vineet from YouTube is, the premium processing, is it available for the H-1B transfers? The answer to the question is yes. The premium processing is right now available everybody. There's no restriction on the H-1B. All cases are eligible for premium processing. Nothing is. Emily, that brings another question to me, is that people say that premium processing will get you the RFEs. Does it actually get the RFEs?
Yeah, I get that question at least 5 times a day. And we file a lot of things in premium processing. We file a lot of things in regular processing. And I don't see any correlation between upgrading to premium processing and automatically getting a request for evidence. If you are getting a request for evidence in premium processing, you would have gotten the same request for evidence in regular processing. There's also a rumor that the scrutiny in premium processing is higher because those officers are more experienced. I don't see that either. We get approvals, straight approvals in premium processing. We get straight approvals in regular processing. There's no difference in adjudication between premium or regular. You're just paying for the faster process.
Richie Boy has this question. Should people pin hopes on their HR 1044, 386 becoming law, given the election year coming up? I mean, the percentage of approval chances is dwindling down. It's becoming lower and lower as days goes by. Richie Boy, what I would suggest you is that if you are pinning on it, no sir, I would not pin the hopes that this is going to be approved. I would do every best of my effort, my little effort that I can do on getting the Senate 386 to be passed. But while you're doing it, if I were you planning my life on this bill, no, I would not plan. I would try to have an alternative, things available. If this doesn't go through, what are the options that are there? I'll be prepared for those things. And if this comes in, of course I will take it. If that doesn't, then I will be having that. Would I make the bill as plan A or plan B? I would think so that I would make, to pin the hope on Senate 386 bill, I would have that as a plan B. I would have plan A, some other option. Emily, do you think is a good statement that I'm making?
Yeah, I agree. Let's see here. I had a question about traveling. So one question was, is it advisable to file the H4 and EAD renewal along with the H1 in premium processing? What's the status of that? So prior to March, we were recommending that you file all three together because USCIS was approving all three together in premium processing. Ever since the biometrics have been in place, we've not seen that. They separate the H4 and the EAD, they approve the H1, and then the H4 goes into the regular processing queue. So is it still advisable to file everything together in premium processing? There's no harm in doing it. But it doesn't create any faster H4 or EAD result. One way could be to go outside the country, get the H4 stamped, come back in, and then use that new H4 I-94 that you get at the port of entry to file your EAD. Then you're only dealing with EAD processing times instead of the I-539 processing times. But that's still, right now, probably 3 to 5 months to get just the EAD renewed by itself. So none of it is fast. Premium processing doesn't help. Expedite requests don't help. Ombudsman does not help. Senator request does not help. Litigation seems to be the only thing that's getting these approvals faster.
Tavish has this question. Can I invest in a real estate properties and use property management firms while I'm on the H-1B?
I think that if you're using a property management firm, that helps because it shows that all you've done is invest, and probably that would be allowed. If you're doing beyond simply investing money in real estate and actually actively being involved in the management of a company or the leasing out of the real estate and doing plumbing repairs and all of that, I don't know. I think that gets a little beyond just H-1B employment. Could be a problem. I don't know. Your thoughts on that?
Yeah, I would be very careful though because yeah, that's going to be an issue. When you're involving anything in the management, that definitely becomes an issue. Rohit has this question: can I become a lawyer in USA on H-1B? Because I see lots of them. Yes, Rohit, you can become a lawyer on H-1B. While you're on H-1B, you can go to law school and you can become a lawyer and you can get a H-1B with a lawyer degree. Absolutely. That I've actually known some people who have done it. And myself, when I became a lawyer, I was on H4 EAD. Actually, I'm sorry, I'm not H4. I did not even have a work status at the time when I got my, when I became a lawyer. I got my work status afterwards through my wife. Yes, you can become a lawyer, and once you become a lawyer, you can file a H-1B. That's possible. You will truly understand much better what the H-1B person goes through if you become a lawyer than compared to what me and Emily have gone through though. You have gone through the H-1B, you have gone through the I-140, you have gone through the process. I would, that's a nice lawyer that I would like to have.
Raj wants to know, he was on H-1B, resigned from his company and left the country, but the employer has not withdrawn his H-1B petition yet. Is there something he should be worried about? No, there's no set timeline when you resign for a company to withdraw. Sometimes the company doesn't withdraw, but it doesn't have any impact on you or your future if they don't.
Question from YouTube: can I invest in stock market on H-1B? That should be fine because you're not actually working for the company. So you shouldn't have any problem investing into it. Jose has this question. His H-1B was being denied. His company filed a motion to reconsider. Sometimes, Jose, the motion to reconsider is not a better option because they're taking approximately about 6 to 8 months for them to act on that. In the interim period, if your H-1B validity is not there, you cannot work. So you may want to reconsider that decision because you can't work and that becomes a problem for a lot of people.
Okay, Praveen Kumar from Facebook had a question about coming here on B1, B2, then converting to F1, and now converting to H1. Does this person need to go for stamping after they convert to the H1? So the only time you need a visa stamp is when you are entering the country. Once you're here, you can file a change of status and you get a new I-94 changing your status. That I-94 tells you how long you can stay. You can change your status again, and that new I-94 tells you how long you can stay. You don't need a visa just because you've changed your status. If you travel, you need a visa to get back into the country.
Janet has this interesting question that pops up, and I want everybody to be careful of what I am telling. Take it very seriously. Janet's mother stayed here for 6 months on a B2 visa, and can she come back within 1 month after she left the country? My advice is no, make sure she doesn't come back within 1 month. Here is the reason, Janet. The visiting visa is here to visit this country into the United States, not to visit India. When your mother has been in the country for 6 months, she's been out of the country and coming back within 1 month. That shows that actually your mother is staying in the United States and she's actually visiting India. So that becomes a problem. I would recommend that you do that thing.
Let's see. Rav Jinder from Facebook wants to know if Day 1 CPT done a long time ago would impact filing an H-1B visa now. Really depends on when it was. Have you traveled since then? Are you applying for your H-1B as a change of status? I mean, if you've been on F1 since 2014 and that's when you did your Day 1 CPT and you haven't traveled, yes, from the day you entered until the day you file that change of status, you have to prove you maintained your status, so it can come up. Now, if you're requesting consular processing, status issues don't come up with USCIS in an H-1B petition.
Can the YouTube revenue that is coming up, is that a status violation for H-4, Emily?
YouTube revenue.
Yeah.
I think
and the
so.
H4, yeah.
Yeah, I think so.
Yeah,
unless
definitely.
you have the EAD.
Definitely. If you are here in the United States, you're contributing to the YouTube, and you're getting paid somehow. That definitely is a violation of the H4. Obviously, if your wife had a EAD, though, that's definitely not a violation. You're good. No problem with that. Josna has this question: I-94 expired and H4 H4 extension. I didn't get the question properly though. Let me answer this question from YouTube, Emily. Janet has this question, same question. Mother was been here for 6 months. Can you apply extension for the mother while she's in United States on B2? We advise not to in this case. The reason is that typically, what's the reason for a mother to be in the United States for more than 6 months? Now, I understand your culture, Janet. I know I come from where my mother lives with me all along. But in USA, the culture is different. When your mother is here for more than 6 months, they don't consider that she's actually visiting you. She's actually staying with you. So that's definitely a big violation. Of course, I'm a US citizen. My mom is a US citizen. She can stay with me. But in your case, since your mom is visiting, they consider that she's actually staying in the United States for more than 6 months. Why would a mother visit for more than 6 months? Is she staying there or is she visiting there? So that becomes a major problem. And when the B2 extension gets rejected, the passport stamping is automatically revoked, and that will create a problem for them to apply and come back into the United States.
One last question from Facebook, from Vijayan wants to know, what is the reason that someone would file an H-1B amendment? I'm assuming that's what's being asked. So an H-1B amendment is required whenever there's a material change in the terms and conditions of the employment. So a material change can include changes in job duties, changes in work location, changes in hours, to where you're working full-time and now switching to part-time, for example, or anything less than full-time. Those are the main, most common types of reasons for H-1B amendments. It has to be a material change in the terms and conditions of employment.
Thank you guys. For you guys, we couldn't attend to all the questions, but we do have a daily conference call. You can always log in, check our daily conference calls at rnlawgroup.com, and you will see every day we do conduct half-an-hour conference calls. You can always make an appointment with me or Emily or any of our 15 good colleagues that work with us and that do most of the RFEs. So if you want to consider, you can always make an appointment. Our schedule is available at RN Law Group. You can make an appointment. You can subscribe to the Immigration Girl blog, and Emily updates it very frequently. Any news that is related to business immigration comes in. Emily, anything else?
Thanks for joining us. We'll see you next week.
Thank you.